Hi, and welcome to our webinar today, all about the recent Schrems decision on Privacy Shield. I am Heather Anson. I'm the Managing Director of Anson Evaluate and a lead consultant with Digital Law UK. I'm happy to be co-sponsoring this today with Digital Law. I also have Peter Wright, who's the Managing Director of Digital Law with me, and Jennifer Baker, a journalist based out of Brussels, and Anna Drozd, also based out of Brussels, who works for the Law Society. I'm going to ask them each to give themselves their own introduction just to make sure, and then you'll come back to me and we'll give you a little bit more of an overview of what we're going to do today. So first, if I can pass it over to Peter.
Yes, so I'm the Managing Director of Digital Law, which is a law firm focused on tech and digital law. So we advise on everything from things like data protection, GDPR, cybersecurity, through to e-commerce, and regulatory compliance when it comes to buying and selling goods in other jurisdictions and helping tech companies with that. I'm also chair of the Law Society's Policy and Regulatory Affairs Committee for the Law Society of England and Wales, and also chair of the Law Society's GDPR Working Group.
Our busy bee. Okay, next, Jennifer.
My name is Jennifer Baker. I'm sort of better known as Brussels Geek Online, and I'm an independent freelance journalist and tech influencer. And I've written for various publications, mostly the big tech ones, so The Next Web, Ars Technica, Computer Weekly, The Register. And I am, as you say, based in Brussels, so I've been following the intersection between EU policy and tech, so trying to work out where that goes. At the moment, I write mainly for the IAPP, the International Association of Privacy Professionals, and CPO magazine, Chief Privacy Officer magazine. And I am, I should say, the editor as well of GDPR Today, which is a weekly newsletter from NOIB. And of course, Max Schrems is the honorary chairman of NOIB, so I should declare that I'm very familiar with this from quite a few different sides. I've written a lot of articles on it. And if you want to read any of them, I will plug it. You can go and find them on brusselsgeek.com.
Okay, and we'll remind everyone at the end how to get that information. Next, we're going to go to Anna, and I'm going to say, unfortunately, we're not able to get her on video, so we will just have to hear her voice. But Anna, can you give us an introduction?
Thank you very much, Heather, and thanks very much for having me. My name is Anna Drozd, and I work as a policy advisor in the Brussels office of the UK Law Society. So we actually work with England and Wales, Scotland and Northern Ireland. And I think that one of my two biggest portfolio is data protection technology, and the other one is trade, especially trade and services. And of course, there's an intersection between the two, digital trade and digitization services. And we've been following all things GDPR for quite a while, and of course the issue of data transfers is one of the most important, one of the important issues for our members, and we continually engage with members on issues data and try to support them, also try to identify which current legislative developments are important.
Okay, perfect. Sorry, we just lost you there, but we can.
Sorry.
That's okay. Why don't we go on to start with our discussion? But first of all, I want to let anyone know who's attending. We will be taking questions if you have them. There should be a question bar on your screen somewhere. If you have any questions, go ahead and feel free to ask them at any time. You just type them in, and I will ask them when we have a chance, if not at the end of our discussion. Okay, so I'm going to actually start with giving you a quick overview. The Schrems case is named that because of Max Schrems, who was originally known for the case that took down Safe Harbor, which is the predecessor to Privacy Shield. It was what had been in place for a long time in the US to allow data transfers between the US and the EU. When that was taken down by the European courts, the answer to that was Privacy Shield, which was supposed to have more safeguards in it, more mechanisms for European citizens to complain, and oversight with an ombudsman. However, Max saw what I think a lot of us saw, which is that it wasn't actually doing what it was supposed to do, and was in and of itself a bit of a sticking plaster. So he went after that as well, and that is where I'm going to hand over to Jennifer, who knows it quite well and can give you more of a professional, probably, overview of the case than me.
Okay, well, I mean, as you said, thanks, Heather. As you said, this is the second Schrems case, so it's therefore colloquially known as Schrems II. The reason that we have these safe harbor or privacy shield agreements is, of course, because the US doesn't meet adequacy standards for a formal adequacy arrangement for the EU citizens' data to be transferred to that country. Only a few countries around the world do. You can look it up online. There's a list of some smaller places that you may be surprised require an adequacy agreement, but that isn't in place in the US. Because primarily the fundamental fact is that we don't, in the EU level, believe that the US takes enough care with European citizens' data. And that's because of their laws and what they allow their surveillance services to do. This all came out following Edward Snowden's disclosures. So it's as far back as that this was brought up in the first Schrems case, saying that, well, the US allows, under many cases, their intelligence agencies and services to spy on European citizens' data. In fact, any non-American citizens' data. There are protections for Americans on American soil, but not if you're in Europe. And so that was why the European Court found in the first instance, in the first Schrems case, that it wasn't guaranteeing enough data protection. The workaround of safe harbor had always been a kind of gentleman's agreement. It's a voluntary scheme whereby the companies that want to transfer large amounts of European data to the US they promise, pinky swear, that they will not abuse their citizens' data. But you still have to expect that the authorities might try to get access to the data, and that's what the court has found. And that is what the court has found yet again, that there isn't enough protection, even with this ombudsman, which the US really dragged its heels in putting in place. There'd been annual reviews of Privacy Shield, and every single one of them was found lacking. So it's not a surprise that the court has found this way, because many, many different organizations, including the European Commission itself, which is responsible for managing the EU side of the affair, had found shortcomings, had found it lacking. So that's what the court found, and they ruled the Privacy Shield invalid. We saw this coming. It's hard to see, unless US laws fundamentally change, how any new mechanism could be found to be secure. However, there are other mechanisms for transferring data between the two blocks. They are binding corporate rules and standard contractual clauses. And these are just sort of template clauses that companies can use when they transfer data. They're approved by the European Commission. They've been used for more than a decade, maybe nearly 20 years, and they can be relied upon in certain circumstances. So for the provision of a contract, for situations where the data obviously has to go, the certain amount of data obviously has to go to the provider in the US. Now, the court said those are still fine.
You have Anna, who works on quite a bit of those, and talking about those a little bit.
I'll leave those to Anna then. And I just want to mention one last thing about this case, which is that people think it's Max Schrems against Facebook. There is a third layer that got involved in this. That's not what this was about. This became about the role of the Data Protection Authority, in this case, the Irish Data Protection Authority. And it actually ended up being Facebook and Max against the Irish Data Protection Authority, which is a bizarre situation. But the end of that situation was that DPAs are now compelled to act if they find data is going to an insecure third country.
Excellent. Thank you for that very succinct overview of that. Now, Peter, I'd like you to talk to us a little bit about what this means more succinctly, what the impacts are of companies who were relying on Privacy Shield in the first place.
Indeed, and I think it's illustrated the danger of relying on the Privacy Shield in this instance. And as Jen was just saying there, we knew that this was going to collapse. And to be brutally honest, I'm surprised it's lasted as long as it has, because you only have to take a look at those annual reviews that we were discussing just there, which make it quite clear in black and white terms the fact that the Privacy Shield has been creaking because it simply hasn't been operating or doing any of the things that it was supposed to and was supposed to do in order to be able to improve on the situation under safe harbor. And this seemed to be both from a lack of political will and commitment in the States to commit to making some of the appointments and some of the drive-through that was necessary for it to work. And also, it was also a fact that really, from the European Commission side of things, each time it was like, are they actually going to walk away from this? Are they actually going to say this is not good enough and we're going to do something about it? And each time it was like, no, we'll send a strongly worded letter, but this was pretty much as far as it was going to go. We were never going to get to a point of this really isn't good enough, and we're now going to, as part of this mechanism, say it's no longer going to work. So it was always waiting for someone to just come along and push it over the edge. And in this instance, it's this court case that has done that. But to be honest, there are even court cases making their way towards the US Supreme Court that might have ended up bringing this to a head as well. So it was under pressure from both sides. And really, I've always felt that the Privacy Shield was a sticking plaster, as was the safe harbor before it, a sticking plaster over a much bigger problem. And that is that there's no federal structure when it comes to data protection in the US. We've got the Privacy Act 1974. We've got different states that have made increasingly rigorous moves towards having a clearer data protection framework. So, for example, in California with California Consumer Privacy Act, which is now being actively regulated and enforced. But it's still not at the same level as GDPR, and it's not as though we've got that uniformity across the US. But even then, when a determination is made, it's not just a matter of saying, do they have equivalent data protection law? It comes down to that package in terms of security and surveillance as well. And because of those surveillance programs in the US that have been in operation and arguably have been continuing to escalate due to the heightened sort of global security concerns from a geopolitical perspective, it's meant that the likelihood of there being any form of determination by the European Commission in favor of the US is more unlikely than ever. And indeed, it's a bit of an indictment when you actually look at the list of countries outside of Europe that do benefit from an adequacy decision. It's a pretty short list. I'll probably go into that in more detail later on, but really it is now a matter of falling back to those original mechanisms, the SCCs and BCRs that Jen was talking about. But just for the avoidance of doubt on that, the SCC, we aren't talking about, oh, we just cut and paste a paragraph into a contract. We're talking about pages and pages and annexes that have to be added to a contract in order for that contract to then comply with what Europe is mandating has to be there. So it's not the work of a moment to necessarily go back and review those contracts and make sure they necessarily work. So it's created significant problems, and it's also made it clear that there isn't going to be something that comes along like the Privacy Shield in 6 months' time to say, don't worry, we can rely on that. Indeed, if you take a look at the European Data Protection Board's guidance, it's very clear that they're saying that's it now. There's no leeway, there's no moratorium. Now it's a matter of falling back on those previous mechanisms.
Okay, and speaking of mechanisms, we'll go to Anna now. What can companies be doing now in this void? If they were relying on Privacy Shields, what should they be doing to make sure that they are transferring data appropriately under GDPR?
So just before I go into different mechanisms, I mean, in the Law Society, we have not released so much guidance. So I'm going to be talking about what I've seen so far and the advice I have seen so far when preparing for this webinar. I think that the advice that I've seen mostly is about first of all to review the data flows and the existing transfers mechanisms so that companies know exactly, especially if they have a lot of operations, where they transfer data, what kind of data they transfer, and what mechanism they use. And of course, if they relied on Privacy Shield, and this is what the EDPB, so the European Data Protection Board guidance states, is that consider other transfer mechanism to be put in place, such as standard contractual clauses or binding corporate rules. But each one of them comes with conditions, and it takes a while to introduce either of them. I think in case of binding corporate rules, the approval that is required from the Data Protection Authority takes a while, and if you have operations in several countries, of course the data protection authorities have to work together, and that takes a while. When it comes to standard contractual clauses, although the court has not invalidated them, they come with very strong conditions of carrying out due diligence. So another piece of advice that actually is is repeating across the materials I've seen, is to carry out, or at least to prepare an approach to carry out such a due diligence. And of course, that happens. Carrying out such an activity to assess other countries' laws is not easy. It will take time. And the problem that I also see is that there is no grace period for companies to actually introduce a new mechanism. That takes time. So especially in the absence of any guidance, which I understand is being now discussed by data protection authorities, and another piece of advice for companies is to keep an eye out on what the guidance may be coming up. There are also additional safeguards in the sorry, not additional safeguards, but other transfer mechanisms such as derogations. But according to the EDPB, those cannot be used for regular transfers, but mostly for one-time transfers, for something that doesn't happen on a regular basis. So for the moment, it's actually hard to see exactly what you should be doing, apart from reviewing your operations and trying to put in place other transfer mechanisms. But as Peter said, this is a very laborious exercise.
Okay, just really quickly, I'm wondering, there's another mechanism if entities are not related, if it's not one company or it's not just one directive, which is the code of conduct, which can be an agreement which is put together between a lot of related entities, but that aren't unrelated entities that are working towards a civil cause, and it has a built-in oversight that somebody is in charge of making sure that the code of conduct is being followed by each of those, so sort of like a mini regulator over that. What do we think, and I can put this out to Anna or the panel, about the role possibly of codes of conduct, even though those take time to get approved by the regulators in charge as well?
Yeah, so maybe I'll have a quick reaction and then let others react as well. I mean, there are, as far as I am concerned, I'm not aware of any of them being approved now, and as you said, they also take time. So it's certainly some commentators point out that this might be an option to consider, but again, it will take time.
Okay. And Peter, I know you had your virtual hand up. Did you?
Yeah, no, it's just to say with regards to the standard contractual clauses, I think that the difficulty here there as well is that it's a matter of, I mean, that can be a significant exercise for some companies. I remember being on the stage at a GDPR conference a year or two ago, and we had the compliance officer for a city law firm there who'd had to go through 3,000 contracts just as part of their GDPR compliance. And if you've now got to go back and look at all those contracts again, with regards to then saying, do we have the right SCCs in place? That gives you an idea of the level of due diligence that could now be required. And we aren't talking about the work of a moment here. And then when it comes to those codes, I mean, Anna's quite right. There's not an awful lot that's sort of out there at the moment as an example of, well, what would that look like? How would it work? The Association of British Insurers has issued a code, and that's currently out for consultation with other organisations. But it doesn't really shed a huge amount of light on exactly how that would work when it comes to this fundamental issue of international data transfers. It was more sort of focusing really on how member organisations would be operating within the jurisdiction of the UK. So in terms of relying on a mechanism like that for these crucial transfers of international personal data, and we must remember that's what we're talking about here, transfers of personal data of EU citizens outside of Europe. The guidance from the European Data Protection Board, which is a little impenetrable because I think it was rushed out, if we're brutally honest, kind of makes it clear that it's very difficult to then rely on an awful lot else apart from SCCs or BCRs in the short term.
Okay. Yes, Jennifer.
I would just echo the other two in saying that I don't think the code of conduct is anything that companies can realistically rely on right now. I mean, you look at the advice that's come through, even on those Article 49 derogations, so there's only 3 times you can use them, which is consent, performance of a contract, and overriding public interest. And even then, like, it has to be non-routine, or occasional. And if you have to go through, if you're a big company with so many data transfers, you have to go through each one of those and say, is there overriding public interest? Is consent? You can't just tick box exercise consent anymore. So I think code of conduct is probably a bit further down the line, and I wouldn't really encourage anyone to think that that's a panacea anytime soon.
I just had to throw that out there as one of those things that's in there, so as a possibility, just in case that's a question that's asked. And because I've worked on codes of conduct, so I didn't see, I agree with you, I didn't see them as a solution because, again, it takes a very long time for them to be approved, and the mechanisms that they actually do cover are difficult. It sounds a little bit like where we are is, as I said, my favorite quote that's applied to GDPR since it started, which is from Maya Angelou, which is do the best you can until you know better, do better. And I don't know that we can say much more than that on that. So now I'd like to ask you guys if you can take a look at the crystal ball a little bit and say, can you see something happening next? I know, Jennifer, you kind of alluded to, I don't know, but think so, but is there a chance for something to replace Privacy Shield that would be better? Is there a possibility of that? Do you see that coming?
Well, I can guarantee you that the European Commission will bend over backwards and tie itself in knots to try and find something. There was also a statement from the US side as well, I think from Wilbur Ross, saying that they're already starting meetings to try and come up with something with the Justice Commissioner Didier Reynders, who they have a big push. They have a real strong interest. It's $1 trillion economy we're talking about here. They don't want to halt data flows. You know, the question is whether you accept that it's data flows at any price, or whether, you know, you actually want to really be a stick in the mud and say, hang on, European citizens' privacy rights matter. And it's going to come down to that level of a battle, because I am sure they will cook up something. I don't know whether it will be the umbrella of data protection or the galoshes of doom. I don't know. They'll give it some stupid name. They'll slap a new label on it and they'll say, oh, but this is better. And if Donald Trump is not re-elected, they might get some small concession on some of these other issues that we have with the allowing within US law. But
I'm writing that down.
Here again.
Galoshes of doom. Anna, actually, if you could come in on this, because I know one of the reasons why it's so important is because it's tied to trade. So do you see that as one of the main driving forces here and how that's going to go? Let's see, do we have Anna? I can't hear you if you can, you might still be.
I am sorry. I just my connection dropped, and I'm sorry I haven't heard your question.
Oh, okay. Because the push for this to have something to replace it, whether I don't know if you heard the galoshes of doom thing, to have it replaced with something. But Anna, since you work on trade, can you maybe talk a little bit of why trade plays such a big role in this?
Well, I think that the amount of the economy is increasingly, well, I think that the saying that the economy is increasingly globalized is actually we all know that, and I think that data flows are one of the foundations for international trade in many sectors, and some more than others. And I think that it's interesting to see that some countries are focusing now on trade agreements that are exclusively on digital trade, and they are looking at such issues such as data flows, data storage, data localization, but also all sorts of technical questions such as underwater cable servicing, managing digital identities, etc. And I think it's from this point of view, it's interesting to see the developments, the legal developments, as in Schrems I and II. So this is something, I was referring actually to the Australia-Singapore Digital Economy Partnership Agreement that was signed, I think, last week. or 2 weeks ago, and I was going through it out of curiosity, what's in there. So of course we are not talking about EU or US in here, but you can imagine that the setting or discussion about international standards of data protection and data privacy is a crucial matter, and of course the discussion on how privacy laws interact with various powers of either law enforcement and intelligence services are actually quite interesting to see. I mean, I don't have any immediate insights as to where it will go, but I'm pretty sure that the debate is far from being over. I don't know what other panelists actually think about it, although I'm sure they might have other insights as well.
Right.
I want to think the one thing that we've got to remember is when we're talking about trade, this is personal data we're talking about. We're not talking about corporate data, that sort of thing. I mean, and there is a point at which you have to say is some of these companies just want to get their hands on as much data, personal data, as they have. I mean, and part of the problem is the business models we have. So if we are in a new world where data is shared in a different way, but if they actually all operated on the principle of data minimization, we wouldn't have nearly as much trouble as we have. And it's because there is this land grab for your private data that this is such a big problem.
Right, but also brings in the irony of the fact that Facebook actually joined with Max Schrems in this latest case, but I've seen from, and in case you didn't know from the accent, American, that Facebook itself has been pushing for more clarity and regulation, and this ties in with this. This kind of goes hand in hand because for them, they are part of the new economy, the new world economy. This making money off of people's data essentially, through advertising, through data analytics, through that. So it's important to them that this be clear, that they know what they're doing, so they don't end up in court all the time. So do we find this, that we're going to have more of these large tech companies like Facebook, like Google, driving the ship rather than the individual countries?
I would say possibly, but I think you still have to come back to the laws of the different countries, because Anna mentioned their data localization, and a company the size of Facebook would actually have no problem setting up the server farms and storing European citizens' data on European soil. The problem is that recently in the US, we have the Cloud Act, which is where they are going to allow, in certain circumstances, with certain caveats, I'm not all over the US law, but they will have the opportunity to allow the authorities to ask American companies for data, no matter where it's held in the world, without getting any involvement, without the MLATS agreements that we've had in the past, the consent of those local authorities to ensure that people's data protection is actually respected. So if one country like the US makes a law like this, and the companies are based in the US, then even if they try to comply in other blocks, they may still fall foul of GDPR or the courts here in the EU.
What, I don't know if they call this that here, but in the US we call long arm statutes, where the long arm of that law goes outside the boundaries. So no matter where it is, it goes, the long arm will reach you. Another interesting aspect of this, and I think Peter had mentioned a little bit, is that one of the issues with the US is it is similar to the EU in the sense that it is a lot of different states with a lot of different laws, and there's only very few laws that the US federal government can actually impose directly on the citizens in each state. And even though California may have a great cybersecurity privacy law, I'm saying great in air quotes, I was gonna add, Jennifer, by comparison to a lot of the other states and to the federal government as a whole, that there can't be an agreement between California and the EU, because like the EU, well, because if it's tied to trade, because the federal government, that's one of the things that the federal government only has authority in, except for the federal government can give permission to California to have that direct agreement.
From the EU side, the European Commission can make an adequacy agreement for a state. That's not in any, I asked specifically the Commission that question, and I was told, yeah, no problem, there's nothing. Bruno Gencarelli told me on the record, nothing in the GDPR that says they can't do that.
Well, I'm not saying from the Commission standpoint. I'm saying from the federal government standpoint, and the limitations of power to the states. And since this is so closely tied to trade, and it's like, you know, the individual countries within the EU can't create really their own trade agreements. It would be this. They would say that California can't create its own trade agreement, and this is a digital trade agreement. So even though there's nothing in the GDPR that says you can't do this, it's something in the federal structure that says the federal government is the one that is in charge of trade deals, and they can give exceptions to different states to do different deals, but that has to be permission that comes from the top.
Maybe one of the other panelists knows. I'm not sure whether the Commission could unilaterally give an adequacy agreement to someone.
Well, I think the difficulty there is that, just using the example there of California, is that there could be some really long, nice, detailed negotiations, but I still don't think they would end up in an adequacy decision, not just because of the issues highlighted there in terms of, well, could California even do that? But because even then, California would still have at its heart the same problems with regards to surveillance legislation as every other US state. And that's at the real heart of this. And this is actually where I think the SCCs could be built on rather shaky ground, is that if we started to really look in depth and say, well, is it even possible for a US corporation to sign up and say, yeah, we're going to look after this data in accordance with the SCCs, when even then it could mean that that data is still being looked at and surveilled as part of these mass surveillance programs in the US. We were just talking there as well about data, and Jen made the excellent point, well, it wouldn't be a problem if there was data minimization by corporations. Absolutely. But we have advised enough clients to know that there are, when they're putting together their systems, where they've either got legacy systems where you can't discern between the personal data and the corporate data and the confidential data. It's just a morass that's together. Or with sometimes advising even tech startups, they will be in a position whereby they've just got, again, all of the data together in one homogeneous zone, and it's then where is that going to be stored? And because that contains personal data, then the issues around international data transfers come into play. But certainly, if data minimization was something that could be handled, then yeah, it would be possible to then play with this and be able to reach the handle issues around data adequacy far more easily. But because it's all tied together, that's where you then start to get these massive problems. And it's also interesting when you then think about, well, okay, the surveillance issues with regards to in the US, arguably even within some of the countries that have adequacy decisions, I would question whether all of those are exactly entirely free of strict levels of government surveillance. I'm not going to pick out any specifically, but you only have to look at the list.
American to say one of our big problems is we're part of Five Eyes. Well, New Zealand is as well, and they have an adequacy decision. So, yeah. But that goes to actually one of my questions with this is all about the security of the data from government intervention and spying. That is at the heart of this. I'm correct in that statement. But there is a big irony in that. And we're seeing that clearly in the UK Brexit negotiations, because one of the big concerns is whether or not the UK will end up with one of these adequacy decisions. Now, I don't know who would like to talk about this irony.
Hypocrisy.
The adequacy irony, the hypocrisy. Yeah, okay, Jennifer, go right ahead. You've got the wording. I know we've talked about that.
Look, I mean, it's true. There's this wonderful thing at the EU level that we call member state competency, meaning that this is all EU level hands off, and you look after that. I mean, it's things like healthcare and education, things like you might expect, but also security services, intelligence services. You mentioned Five Eyes, and I think you're right. There is a hypocrisy there in that if you're part of the EU, you're part of the club, so we don't look too closely at what you do. Once you're out of the club, as the UK will be in a matter of months, then suddenly, oh, you need to meet our standards of data protection. And if you spy too much, we don't like that. I would say that the US and the UK and then the other five, I mean, the other five countries to a lesser degree, have huge surveillance and intelligence machines, unlike anything else you see within the EU. You've maybe France and Germany have something, but they're not, you know, they're a fraction of the size of GCHQ. So, I mean, in terms of where the real dangers lie, they might be slightly different. And that's only a small mitigating thing. In principle, it's hypocrisy, yeah.
Who do actually outsource that power to some of these countries within the EU? So it's almost like a clearinghouse for a lot of data. So there is sort of a little bit, and being an American, I kind of go, look, we have more protections than people think we have. But then again, you look at the other countries and say, wait a minute, are we being really fair with this sort of comparison? And by not being fair with that comparison, are we disadvantaging actually the European Union? Or I don't think the US is going to feel that disadvantaged, except that over the UK, but the UK can be massively disadvantaged. So with these adequacy decisions, is the EU disadvantaging itself and the smaller jurisdictions such as the UK or other trading partners around the world? Anyone?
It depends what you think the EU wants to do. The EU has set itself this task of being a world leader in privacy. It sees that as a potential USP, a unique selling point for businesses within the EU, for you know, it as a trading bloc, and that's the position it's taken. It's understandable.
Or the Switzerland of data.
Yeah.
But the problem with that being that Switzerland could do that with money, but it's hard to keep data. You can't really hold it in your fingers like quite the same way. So do we see these adequacy decisions themselves being questioned, or is that a possibility in the future that the EU may have to look at another way to really make this happen?
They may not stand up to scrutiny. There is also the fact that to a certain extent this could start to become a significant break on the progress of global trade. It'd be interesting to bring to hear Anna's thoughts on this, because I was listening to a podcast just this morning from an advisor on UK trade who's currently engaged in the negotiations with Japan and other countries, and they were actually saying, well, look, there are issues with regards to the fact that, if anything, global trade is in fact falling at the moment compared to where it was a few years ago, and obviously it's only going to then significantly more fallen back this year for reasons of the global pandemic, as well as trade wars between some of the largest players in that. And then the fact that when it comes to the EU being able to negotiate its trade deals with other economies, there is always this sticking point of data. That could mean, you know, it is meaning that you can't roll out those deals as quickly as you might otherwise want to. I mean, there was a list on the list at the moment on the EU's website. It says they're currently talking to South Korea. Now, what's one of the big roadblocks going to be there? Well, think about it. South Korea has got a very belligerent neighbour to the north, regularly threatening to use ballistic nuclear weapons. So take a wild guess in terms of the level of surveillance that country, in order to survive, has got to have on most of its population. And you think, yeah, I can't see them being able to pass through the eye of the needle, as it were, to get that adequacy decision. And we talked earlier on, well, what about the UK and Brexit? I can't see the UK, with our Investigatory Powers Act, being able to pass that measure, let alone the fact that then with the UK being outside of the EU, and we're then thinking about Russia and China and the US and other players, state surveillance could very well increase. And there was only a decision this week with regards to the use of CCTV and facial recognition software, which was found to be illegal under the current framework, but it's certainly the direction of travel, whereby the governments are having to consider these measures in order to, in their view, be able to keep us safe. And let's face it, one of the issues now to think of in future is going to be issues around public health and the mass collection of data there. So this isn't really helping the development of those frameworks and the future developments of governments, where they're going to be trying to keep us safe. And it just leads, if anything, to potentially more protectionism, which isn't going to help world trade.
Anna, did you have anything to add on that?
Well, it's hard. It's hard to add anything because I second what Peter said, and indeed, um, um, especially in the in the context of global pandemic and our sudden reliance on a lot of technical solutions to keep working remotely and to keep functioning. I mean, that there are institutions that had to switch into remote working overnight. But also the importance of trade relationships and very complex global supply chains, that is all now being redefined also as a result of pandemic, but also as a result of some of the countries taking a bit more protectionist stance than before, and adding to that the standards that are now set by the judgment. They are putting very high ban not only on on other countries' legislation, but also on the data exporters and importers themselves. One of the interesting things I was looking is that those who export data with the help of importers will actually have to carry out quite an assessment of the country's jurisdictions, and the concern there was that these decisions may be different, that these assessments, first of all, there will be many of them. Secondly, there is a risk that they might be different with regard to the same country, and this was raised as one of the uncertainties that is likely to follow. It hasn't happened yet, but we will see. So I don't have any immediate reactions in addition to what Peter said, and say for what I just said now. Only that it will be very interesting to see what next actions will be taken internationally by the Commission and the US, of course, but also with regards to other countries.
Exactly. Well, we do have a question from one of our panelists, which actually ties in with something I was going to ask anyway. So this is from Kevin O'Farrell. So what about, quote, supplementary measures such as encryption to stop any mass surveillance for data in transit? And I was going to bring this up in terms of, let's say, the Apple versus FBI case that came years ago, where the FBI wanted to get into a phone and Apple said, don't care if you have a warrant, you're not getting into this phone because we don't have the ability. So using some sort of encryption to say, no matter what the surveillance is at a company level, we're not gonna allow this to get in. So is that something that can help companies protect your GDPR?
Well, I would say in the case of the San Bernardino iPhone, which I guess is the case you're referring to, that in the end they did get into the phone because they use an Israeli company. And as you see, Israel is on the list of adequacy decisions. I know Peter didn't want to pick out individual countries, but I'm happy to do so in that case. Yeah, I mean, end-to-end encryption for data in transit, sure, but I think our bigger concern here is not so much about data in transit, it's about data stored data. So yeah, I mean, and if you're a company like Apple that says, you must really compel us, and we can't get access, then sure, that does. I mean, and that's, it's one of the reasons I like Apple. There's lots of reasons I don't like Apple, but that's one of those few reasons that I do. I mean, one of the reasons I would say, pick other companies, take Microsoft and the long-running warrant case where they were refusing to hand over an email that was stored in Ireland, because that's what just happened to be where their data center was, to a New York court. And it went over and back and over and back, and the courts in the US didn't want to use the mutual legal assistance treaties, and instead wanted to compel, a la the now Cloud Act, this predated the Cloud Act, Microsoft to hand over the email. So if companies can say that they can't do things, but we all know that there are workarounds, and if a country is willing to make those workarounds, I don't see how a court could say that the data is still safe.
Mm. Exactly. Then I'm going to kind of move the topic again, which is the European sentiment is the EU sentiment is they want to be, the safe haven for data, and they're putting all of these restrictions in place. And Max Schrems definitely is a believer in that as well. But is that something that everyone believes is the right thing? Is that the majority opinion? And the reason I have two reasons for for thinking that this may not be the case. One is I teach or used to a summer school for lawyers, European lawyers, and one of the courses I've done is a workshop on security laws. And I say, okay, well, we're going to start our own little country. And after we do a review of different types of surveillance and surveillance cultures and surveillance laws, then I say, okay, we're starting a new country from scratch, and you have to create the surveillance laws. What are you going to allow? What are you not going to allow? And what is that? And because we have people from such different countries with different ideologies, they were surprised at how different their classmates' opinions were on the limits of data surveillance. I mean, we had somebody who used to be in law enforcement and so had a very even a difference between someone from the same country, let alone some people from Russia and from Estonia and from lots of varied places. So there was that. And then I was doing a webinar about a month ago with some professors, academics, around the Trace and Track app that the UK was looking at, and they were very much in arms about this is not compliant, this is not the data, we don't know what the data is going to be used for. But then there was a very distinct question I asked at the end. It's like, well, how many of you, and I was on the panel, I said, how many of you are actually going to download and use this app if it's made available? And they all said, yeah, we will, because they felt it was a responsible thing to do. And I said, but there's a difference between, there's now a cognitive dissonance there between, we don't think this is a secure and safe thing, but we're willing to download it and use it.
I don't necessarily think that a track and trace app is a particularly helpful example, because there's a lot of social pressure. Even if you weren't going to download it, you'd look like, I don't want to say what, if you said you weren't, there'd be a lot of public shaming going on around that. I think it's more the cognitive dissonance between me saying, I don't want to be tracked, and then using Google Maps or something, or, you know, I don't want to, and we all do that every day. And that's because it's made so difficult for us to opt out. I think it's not actually such a strange cognitive dissonance. It's like we want to be privacy, but we have a certain threshold over which we just have to get on with our lives, which is why you need people like Max out there doing the hard stuff, showing that what is supposed to be within the reach of every EU citizen actually isn't, that it takes 8 years of a young man's life just to get to, you know, one court judgment. And I would say, though, in terms of whether you think there's an appetite for it or not, there was a Eurobarometer survey, I think in February this year, on the GDPR, and it showed that, I mean, it varied obviously from country to country, but it was pretty overwhelmingly positive citizens' attitude towards the GDPR. You know, there's huge numbers, you know, 80% or something, 89% had heard of it, and mostly it was positive reactions. So, I mean, if you want to find out a bit more detail, look at that survey.
Would that change, though, if they knew about the competency? If they knew what was and was not in GDPR?
I think there's been a pretty decent public relations effort on GDPR from the part of DPAs in different countries, as well as the European Commission, to say that this is about your rights. And I mean, it fundamentally is about citizens' rights and personal data. So yeah, I mean, nerds like us might drill into it. I might say, yes, this is hypocrisy when other countries have to abide by higher standards than we put on ourselves. But I would still say, on balance, better to have it than not have it. As a citizen, as a you know, consumer rights person, digital rights person, that's my view. But of course, you could ask the next person, they'd say something different.
Certainly. Anna, did you have anything to put on this?
Not immediately, but I did note your remark about how different views on privacy and on the extent of surveillance would be acceptable, you know, around the world. And you have I think there are profound cultural differences how we see privacy and how we see individual rights. And I think the most recent tension and the debate on the, you know, track and trace programs, whether it's an app or not, was actually a great example to observe the debate globally, how you actually have to approach the you know, tackling the pandemic, and how different the reactions were in countries such as Korea or Japan and the US and some EU countries. So I think that so I note that the attitudes towards government surveillance would be would be similar, although they might follow different patterns in different countries. So it is a space to be watched in the future, and it's something to be mindful of when we actually talk about trade policy and setting international standards. That for some countries there are some what may be seen as a minimum standard in the EU will be actually quite advanced in some other countries, and not because they don't have regulatory regimes that are developed enough. It's just that they look at certain issues in a completely different way.
Okay, Peter, any last thoughts on that?
Yeah, I just wanted, we were just talking there about the sort of level of awareness around privacy and data in GDPR, and it was interesting the results that Jen referred to there on the survey. I think it's always quite important though to sort of, and I've found this difficult in the past as someone who works in this sort of stuff every day, to then sort of step outside and think, well, what does the average person think about this? And I, as part of that, I had a chat with a TikTok user yesterday. So, show me how TikTok works and how that operates.
I mean, you're not on it, Peter.
Funnily enough, no. The idea of posting videos of myself dancing to different things didn't really appeal there. And apparently that's what you have to do to become the #1 ranked person on there with 70 million followers or whatever. But it was interesting when I then had a chat with the person. I was like, so do you get, in terms of the information that app is taking off your phone, as or anything else from Facebook or whatever, how that data is being taken, where it's potentially going, of course, going to China rather than California, as has been very often the case in the past. And the interesting thing is that those issues and concerns with regards to privacy were nowhere on this person's radar. Yet they were using apps, social media, everything. They have grown up with it. I actually asked the question, when did you first start using digital technology? And the answer was, well, I was on Facebook at 8 years old. So that gives you an idea of the fact that people are now growing up as digital natives. And I think very often they are very much accepting of that technology and not necessarily thinking about the privacy implications of it. And yet within the sphere, when we're talking about privacy and when we're talking to, like on this discussion now, we're all heavily engaged in this sort of stuff. Sometimes I think we get a slightly skewed perception in terms of, well, what's the average person's thinking about when it comes to these issues? Are they particularly worried about privacy? Are they worried about security? Are they worried about government surveillance? And very often the answer is, they really aren't, as long as they can go ahead and order the pizza or watch the video or download the music. That's kind of all they're really worried in. But then it gets quite worrying in terms of, well, how far does that go? What are people willing to give up in order to have the nice bells and whistles in return? And it's interesting how that conversation has now changed with a player like TikTok, where now in the US, irony, they're turning around and saying, we don't like the idea of this big successful app that millions of Americans have downloaded, and the fact that data can now be accessed, because under the law in China, if the government turns around to a company and says, we would like to have a look at your data, that data then has to be provided. And the irony is that's exactly how Europe's been with America and its security laws over the last 20 years.
It is, however, not difficult to scare a teenager into caring about that. You just simply say, that data is stored somewhere. If that gets leaked, your mum and dad can see it. And suddenly they do care about data protection.
For about a week, and then they forget. It's interesting. That touches actually what Peter said on the TikTok thing about one of the big differences between sort of the US culture around privacy and the European culture around it, which is the US citizens in general are much more trusting of companies to be safe with their data, and they don't trust the government at all. So there would be the issues about the government surveillance and there being sort of this big hole and gap in what the government can do with your data in GDPR would not have flown under the radar in the US at all. We tend to be more distrustful of the government misusing our data which is actually surprising of me, because we don't have as much history as some European countries do of the governments themselves misusing people's data. I won't name countries on that one, but that is a cultural difference, and it's interesting their view. So TikTok, the US users aren't as worried about that so much, but the government then became worried. And then now the people are going, well, why is the government worried? Because we're worried about them. So it's a very interesting cultural shift between them. But I think we are coming to our end, so we're going to wrap up. But I want to make sure I give you each a chance to let us know how people can find you, not in a bad way. Not to give away some of your privacy here by telling us how people can read your articles, reach out to get some assistance or get more information. So we'll start with you, Jennifer.
Like Peter, I am not on TikTok, so you'll have to find me on Twitter. Brussels Geek is the handle I go by there. I also have a website, brusselsgeek.com, which I aggregate all my stories and so on. And you can sign up to the GDPR Today newsletter by going to NOIB, which is short for noneofyourbusiness.eu.
Excellent. Okay, Anna.
You can find me on LinkedIn and Twitter. My Twitter handle is Anne Agnes. But also you can read about some of our activities and some of the topics that we look at lawsocieties.eu and on my LinkedIn profile as Anna Drozd, MCIPR.
Excellent. Okay, and Peter Wright, who is digital everything except for TikTok.
Indeed. So on Twitter at Digital Law UK. Also, we have a Digital Law Facebook page. So just search for that on Facebook. We have also been producing these webinars, other webinars with Anson Evaluate, which go out as webinars and podcasts. You can take a look at previous webinars we produced at digitallawuk.com. We also, if you search on your podcatcher of choice on Android or Apple, you'll be able to find Digital Law as a podcast channel. So you can then listen to that content and get a notification of when we've got new stuff coming out as well, most importantly. And we've also got our website, digitallawuk.com, that has not just the videos, but also other regular blogs and updates. And I'm also on LinkedIn, and if you just search Peter Wright Lawyer, you'll find me on there as well.
Excellent, thank you very much. And just for myself, Anson Evaluate, we're pretty traditional channels. We've got the LinkedIn and the Facebooks and the Twitter. But if there is a particular event or webinar that you would like to hear, because this is one of the things we do is produce content that that people want. So if there's something we haven't done, you can get in touch with us by one of those mediums, or you can email us at events@ansonevaluate.com, and that's a bit more direct. Also, as a reminder, this is going to be available as a recorded download. So if you weren't able to stay for the whole thing, or if you know somebody who might be interested in the topic, please feel free. And many of our other webinars that we've produced are available that way as well. Once again, I want to thank my guests very much for attending, and thank my attendees very much for being there for us. And we'll see you again soon, hopefully. Have a good day.
Thank you very much.
Thank
you. Thank you.